What are 3 instances as you are contemplating bringing a lawsuit against a careless doctor or hospital staff where there are going to be disputes in your particular matter? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The first dispute is likely not going to come from the opposing side, but rather from the expert that your attorney hires to evaluate your records. That's the first thing. The second thing is that assuming you have a valid basis for a case and your case gets up off the ground, now when the defense prepares a document called an answer to answer the allegations in your lawsuit, that is the second time that a dispute is going to arise. What is the third dispute that I'm talking about? The third dispute is, as you now get into your lawsuit, we are obligated to provide authorizations known as permission slips that will allow the defense to get copies of your medical records from the various doctors whom you have seen, as well as the various hospitals where you were treated. Why is that going to be a dispute? I'll tell you why. Because oftentimes the defense wants to go back many, many years to see and to learn and to find out about your past medical history. Typically, we provide the defense with 3 years worth of your medical records, or at least we provide them with a permission slip so that they are authorized to get 3 years worth of your medical records. Many times the defense turns around and says, listen, this is not sufficient. We want to go back 5 years, 10 years, 15 years to see all the problems that you had going back all those years. That's the next dispute you are likely to encounter. So let's go back for a moment to the 3 disputes that I'm talking about. The first dispute will likely occur when an expert reviews your records. You believe that you have a fantastic case and that the doctor did everything wrong. He screwed up big time, causing you significant harm and injury. The medical expert that your attorney hires may not agree. In that instance, you are going to be upset. You are going to be frustrated. And now you're going to say, get rid of this expert. Let's go hire another expert. Well, there are some instances where your attorney will go ahead and hire another expert to review your case. However, you may not have as great a case as you believe, in which instance you are going to be very upset, very frustrated, and that's going to be your first dispute. The second dispute is going to come when you have a medical expert who confirms that you do have a great case, you do have a good case, and now your attorney is permitted to start your lawsuit. When you start the lawsuit, your attorney has to prepare a document called a complaint. He then has to take that complaint and deliver it to the people whom you are suing. That persons, that doctor or hospital staff, then has to take that document, that complaint, and hand it off to their attorneys. Their attorneys then has to respond to the allegations, and that's done in a document called an answer. It's a fancy legal term called an answer. They're really responding, they're answering the allegations. And in those allegations, they are denying pretty much every single thing that you're saying. Importantly, they turn around and say, hey, why are you suing me? I did nothing wrong. That's defense number 1. Number 2, they turn around and say, you know what? If I did something wrong, so did you, Mr. Patient. That's defense number 2. Number 3, they say, you know what? If I did something wrong, whatever I did not cause and contribute to your injuries. That's defense number 3. Then they turn around and say, you know what? If I did something wrong and you did something wrong and I caused you harm and injury, well, guess what? Your injuries really are not as bad as you claim them to be. That's defense number 4. That is when you are also going to be upset and frustrated to learn that the defense not only is pointing a finger at you, saying that you caused and contributed to your injuries, but they've denied all of your allegations, and now they're trying to deflect why you suffered these problems by saying it wasn't me, and if it was me, guess what? I didn't cause your injuries, and if I did, you know what? Your injuries really are not that bad. That is the next time you are likely to be upset and frustrated and angry because the defense is denying all of your claims. And the third time, now we talk about the authorizations, the permission slips, where the defense wants years and years worth of your medical records, when in fact they are only legally entitled to receive 3 years worth of your medical records. So why do I share this information with you? I share it with you just to open your eyes because I want you to understand where the disputes are in these types of cases involving claims against doctors and hospitals. And now, as you're deciding whether or not to go forward with a case of your own, whether or not to go ahead and bring a lawsuit against a careless doctor or careless hospital staff. I want you to be aware of all of this that occurs behind the scenes that nobody really talks about. I recognize you'll likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so and have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.